Good afternoon, guys. My name is Alena Shautsova. I'm an immigration attorney from New York. And in today's live, we're going to be discussing the most recent immigration news. New proposal for Dreamers, or the DREAM Act 2023. Title 42. What is going to happen and why the United States Supreme Court decided not to hear arguments related to Title 42. And I'm going to also give you some tips about family-based immigration. So thank you very much for joining. If this is your first time here, welcome. Do not forget to let me know where you're watching from. Again, my name is Alena Shautsova. I'm a practicing attorney from New York, but I help people in all 50 states and overseas. I help with waivers, various issues such as asylum, removal, pretty much anything and everything. And if you need to reach me, you can do so by calling the number below, 917-885-2261. Do not forget to like, share the stream, and we are going to start. I'm sure that you are eager to find out what's going on in the United States immigration system, what's happening, and what is there to come. So let's see. The U.S. Supreme Court cancels all oral arguments in Title 42 border security case. Why is this Title 42 is important to us? Well, because if you recall, every time an immigration reform was on the table, every single time there was an issue of border security, the side that does not want to change anything in the United States immigration laws is arguing that the border is not secured. Title 42 was first adopted during Trump administration in response to the pandemic. The notion was that Title 42 is going to stop immigrants coming through the border, even asylum seekers, and our country is going to be more secure, will be safer in connection with the health crisis. But slowly but surely, Title 42 crawled into our United States immigration system and has been used even after the peak of the pandemic. And of course, it was a convenient way for the CBP to disallow immigrants to the United States. But not all immigrants, but certain immigrants. And that is the huge problem with Title 42. As you may be aware, there was a lawsuit. Parties were going back and forth, and eventually the matter was pushed up all the way to the United States Supreme Court. One of the mechanisms that was developed in order to allow some immigrants to come to the United States during the Title 42 implementation was CBP-1 app. You may be aware that starting the beginning of this year, about certain people can enter the United States without being issued a visa or having a green card if they register with the CBP-1 app, which is a special application downloadable only if you are in Mexico, in central Mexico or in northern Mexico, next to the United States border. And this CBP-1 app application was developed again to grant people exceptions to Title 42 prohibition on coming to the United States in connection with a health crisis. So the matter was supposed to have been heard by the United States Supreme Court as to whether or not Title 42 should be allowed to continue and what we're going to do about it. But guess what? Supreme Court canceled the oral argument because Title 42 is set to expire in May of this year. And as such, the whole controversy will be moot. It's going to stop being a controversy. There will be nothing to argue about. The Biden administration is planning not to continue with Title 42, and it also poses a risk to CBP-1 app. logically, if Title 42 is no longer in use, then CBP-1 app probably also will cease to exist. However, I have doubts about that. I think that CBP-1 app, as a practice of allowing asylum seekers and certain vulnerable population into the United States, is going to continue to exist. And of course, we're going to find out about it in May and June. So we can have some prediction. You can share your thoughts as to what's going to happen, and I will share mine. As I said, I believe Title 42, even after it's stopped being used, even after it's not used anymore, I think CBP-1 app will be used. So we're gonna see what's going to happen. But it's an important news. Why? Because it's all tied up together with another important, very important information that I would like to share with you, and it relates to potential reform. Potential reform, of course, not for everyone, but for dreamers. Again, we have rumors, news that dreamers may have relief. Dreamers usually are referred to, or this term is being used about kids who were brought to the United States at an innocent age. They did not know what's happening, but they stayed in the United States, grew up in the United States, and now visit people in their early 40s, guys. This is how long this issue has been continuing in the United States after the problem was acknowledged. Kids grew up into young adults, middle-aged adults at this point, and new legislation is being proposed to give them some relief, to allow these kids to finally get green cards. And this particular version of the DREAM Act, because you may be aware that within the past 10 or so years, there have been different versions. This one will bring relief to those young adults or children who were 17 at the age or younger at the time rather when they were brought to the United States. And they have to also show that they have lived continuously in the United States for at least 4 years prior to bill's enactment. So technically, this particular version of the bill is going to cover not only those who are in their 40s, but also those who are at least 21 about, right? There are other conditions, of course, such as paying an application fee, past background checks, good moral character. Perhaps there will be other addition versions and modifications. What I'm publishing on my screen is not an official version of the bill, it's just a summary. And I'm not sure if it's going to change because last time I checked, an official version of the bill has not been yet published. And today is a federal holiday, so I don't think it was published yet. But obviously, it's a good start. Many will criticize this proposal, I'm sure, saying that it's going to take too long for the kids to legalize and so on and so forth. But you know what? I feel that anything at this point will be better than nothing, because I know hundreds, personally know of young adults and children who do not have any opportunity, any relief from their situation that they were placed in involuntarily. They did not seek this situation. It came upon them when they were brought into the United States as kids, and now they're stuck. Many of them, almost all of them, speak absolutely perfect English. You will never know that they were not born in the United States. Many of them hold extremely important jobs, such as EMT, firefighters, educators. You know, many dreamers have work permit due to Obama's DACA program. But at the same time, if they're not married to a US citizen, for example, they cannot get paperwork. They cannot get a green card. And it's unfair because they've been contributing into the society for several decades at this point and don't have anything back. According to my knowledge, they will not even, unless they fix their status, they will not even will qualify for Social Security once they are retiring. But if you have information to the contrary, you can share. So this is where we stand right now. Taking into consideration Biden's attempts to get a better grip at the situation at the border, this time around, perhaps taking also into consideration that we are getting closer and closer to our election year, we may finally see some improvement in this particular area. And this is, I believe, very good news. And you tell me what you think about this. You tell me if you believe that you may benefit from it. Again, it's going to cover those who were brought to the United States before they turned 17, right before or at the age 17, I believe. And you have to show that you lived here for 4 years, passed security background checks, and so on and so forth. So we're going to see how exactly it's going to work and what's going to happen with this particular proposal. And the last thing I wanted to cover is family immigration. I feel that there is a lot of confusion with regard to this particular topic. Specifically, what's going to happen if an adult son or daughter stayed in the United States, overstayed their visa, and now they have a parent who is a US citizen and can sponsor them. So guys, if a parent who is a US citizen is submitting paperwork or I-130 petition for an adult son or daughter, there will be a priority date and a long wait time, at least 6 to 8 years wait time, if the person who they're sponsoring is not married, and even longer if they are married. But in the end of this tunnel, there is still no light for most of the people who are overstaying their visa and would like to receive a green card in the United States. Why? Because in the preference category is everyone who is not an immediate relative. An immediate relative is only a spouse, a child under 21, or a parent of a US citizen. So if you're a son or daughter, you're not an immediate relative. So in the preference category, in order to adjust status in the United States, receive a green card without leaving the United States, a person must show in 99% of the cases that they maintained lawful non-immigrant status throughout their stay in the United States. And most people will not be able to do that. However, there is a way out of this situation. It's an I-601A waiver. For those who will qualify for the I-601A waiver, there will be a way out of this situation, but the person, if the waiver is approved, will have to travel overseas, get the immigrant visa, and come back. So I just wanted to mention this because I feel like there is a lot of confusion about, parent sponsorship. So now you know what's going to happen and how exactly it is happening. So now, guys, if you have some questions related to the United States immigration law, I'll be very happy to answer them. Hi, Ali. Thank you for watching. Ali joins every time. Thank you, Ali. Thank you. Hi, Morgan. Hi, Mido. Any update on essential workers? I'm sorry, Ali, there is no update at this time on essential workers. If you hear anything and I have not mentioned it, please ask me and I will provide my comments. Hi, Ketuman. Dave, I'm sorry. Hi, Dave. Can you advise what the ideal time period will take for work authorization after U visa petition? I would love to do that, but I do not know. I believe that U visa related work authorizations, while the U visa is pending, were implemented in 2021 for the first time. And since then, none of my cases so far have received those letters authorizing people to file for the work authorizations. So if I had to guess, I would say at least a couple of years. I know that some lawyers reported that cases that were filed in 2017, last year, were receiving such authorizations. So it's hard for me to predict when exactly a person may enjoy that work permit. Hi, Milo. Greetings from Phoenix. Yay! I filed I-45 together with work permit and travel document. How long more do you think we'll wait if I'm waiting for over 5 months? If you file based on marriage, I would say that this is about the time for you to receive that work permit and authorization to travel, unless you guys were issued a request for more evidence. Very often, United States, USCIS sends you a request for more evidence for the information you already provided to them, but it stops the processing time clock. So when you get that request for more evidence, try to answer it as soon as you can, just so you will be able to get the work permit faster. Hi, Edwin. Any updates on Asylum relative petition form I-730? I really do not know of any fresh information with regard to this form and processing. If you've heard of anything specifically and would like to ask me, now this is the time to do that. This is the time to do that. Thank you, CH. Thank you, Mido. I'm not commenting on controversial comments here. Let's see. Hi, Nadij, I won't. Working in the hospital, stand up early. It's okay, no problem. This particular thing is going to be recorded, this presentation, so you can always go back to it, and if you have to go and disconnect, it's totally fine. Hi, Jeffrey. Hope all is well. Please, with my biometric appointment notice is not in. I request for another one, but still not in. Why is it taking so long? Jeffrey, I have to tell you, you're not the only one who's frustrated with regard to this specific issue. Something is going on with those biometric appointment notices. In 2 of my cases, they came late. And in one of my cases, my client was allowed to have biometrics on a random day. The client just came in and stated that, oh, I just received my biometric appointment notice, and the supervisor allowed her to be fingerprinted. But in another case, the supervisors refused a client to be fingerprinted, even though it wasn't the client's fault that the biometric notice did not come in time. And we did request also, just like you did, for the biometrics to be rescheduled, and it's taking forever. So you should contact your local congressman, as we did. We're also waiting, but I hope that we're going to get a resolution of this particular issue, very frustrating issue, soon. Hi, Walid. Any news on asylum cases? Not really, guys. I wouldn't say that there is any new information. Asylum backlog is keep growing. Now, more than 1 million cases are pending in USCIS, I believe, and an immigration court. It's crazy. Hi, Angelica. Why I-601A visa is taking too long? Probably you're referring to a waiver, I-601A waiver. Guys, I really do not know. When we first started filing those I-601A waivers, it would take us maybe 6 months to receive an answer, and now it takes 2+ years. I'm not sure what really happened, but it seems like they just do not have people to process all those I-601A waivers, and tremendous backlog occurred. I think it may also be related to the way consulates did not work during the pandemic, and somehow all related, and that's why we're in the situation we're in, but it does take a very long time. I will not be surprised if USCIS is going to be sending our RFEs just so that the evidence will be updated. Hi, Sustainable Green Builder. I got married last October to a US citizen, but my wife lives in a different state due to my work. Does it have any negative effects on my adjustment of status? I hate to break it to you, but it will. There is a group of red flags that USCIS officers are trained to look at, pay attention to. And one of those things would be the address, whether the spouses are sharing residence together or not. This is one of the first things they're going to be asking you for, at least to show that you're sharing residence. Is it possible to overcome negative effects? Yes, it's possible, of course. If you have a particularly strong reason as to why you do not share residence, if you share some other things together, your bank account, bills, insurance policies, perhaps you have very strong social media presence showing that both of you have a real relationship, and perhaps you're thinking about expanding your family, I'm talking about children, then of course you may overcome this particular aspect of your relationship and its effect on USCIS. But I'm not going to be surprised if you guys are going to be called for the interview and it will be one of the biggest issues. All right, and now I'm going to take my last question for tonight. Hi, Jonas. Does Overstay licensed medical laboratory scientist qualified is probably not qualified for national interest waiver? The national interest waiver is the EB2 preference category. Generally speaking, you have to be in lawful non-immigrant status to file for an employment-based green card in the United States at the time when an application for adjustment of status is submitted. The law does provide one narrow exception. You may have 180 days of a gap between your lawful non-immigrant status and the time when you submit your application for adjustment of status. No more than 180 days. However, if during that overstayed time you also worked without authorization, each day is going to count as 2. Don't ask me why. I don't know why. So for example, let's say you have 5 days of overstay. And during that 5 days, you also worked. So for that particular exception, it's going to count as 10 days. So whether you would qualify or not, I guess depends on the time of your overstaying, right? And if you also engaged in unauthorized employment during the time. Well, guys, thank you very much for joining and for watching. Don't forget to like, share the stream, and help my channel to grow and to have more and more visitors and subscribers. I'm always happy to share the most recent immigration news with you, especially when it's good news. I hope you all had a great day off, if you did have a day off today. And I'm going to see you next week, hopefully, and share some more good news with you. So thank you very much for watching, and I hope to see you soon.